Claren, you want to reserve some rebuttal time?
Yes, Your Honor, 5 minutes, if I may.
That'll be fine. We are ready when you are.
May it please the court, Your Honor, Scott McLaren here with Marie Borland on behalf of the appellant, Highwoods Properties. In this case, the trial court entered an order enforcing an alleged mediated settlement agreement, and we're here asking this court to reverse the trial court. By way of background, this was a three-party case, a plaintiff, American Integrity, and two defendants, us and another tenant at the building, ReliaQuest. And the case was a lease dispute involving signage rights to signs on the exterior of an office building. Before our co-defendant, ReliaQuest, could even file a responsive pleading, all three parties agreed to mediate the dispute.
Mr. McLaren, can I just let me see if I could maybe cut to the chase and deal with the issue that's really before us. Help me out. In this case, I think we all agree this was not a court-ordered mediation. You agree with that?
Yes, Your Honor.
All right. And this is simply all the parties decided to get together, and I think you did the notice, or one of you did the notice. Hey, we got this mediator. This mediator is ready, you know, to come in and such and such a time, such and such a place, and then the mediation went forward. And then in the mechanics of the mediation itself, because the way that I review this is that we're dealing with two separate issues. Number one, was there an acceptance of the offer? Was there an actual agreement, number one? And then secondly, what are the mechanics in terms of whether or not, you know, it was properly accepted, and what are the mechanics involved with that? So let's focus first on the first part in terms of the acceptance. Are you taking the position that you have not accepted the terms, what I call the essential terms of the settlement in this case, Mr. McLaren?
Yes, Your Honor, we are, because there are no terms that could possibly be enforced as an acceptance. If you look at the terms of what purports to be the settlement agreement, first of all, the email itself says that Counsel for American Integrity is going to prepare the initial draft of the settlement agreement.
Okay, no, that's not my question, and that's a separate thing, because you agree. I'm looking at the emails that have been exchanged, and as I see the email is that, okay, here's what I call like four paragraphs. And then I get an email from you that says, I accept. And then it says, and we're talking about the four, what I call the essential. What you're alluding to right now is later on that, okay, then who's going to be preparing the documents, who's going to be the settlement agreement that's going to be prepared, the release and so forth. But I'm going to the initial exchange where, and let me kind of backtrack, Mr. McLaren. The mediator, this was not resolved at the mediation itself. I think we could agree on that. It's very clear.
That's correct.
All right. And then it went on, and the mediator took upon himself, it's to kind of be the conduit between, you know, both parties. And then if you look at the emails that were exchanged, this is where, help me out, is what part of I accept is not deemed an acceptance of the things here.
I'm sorry, Your Honor, are you finished? I'm sorry, I didn't mean to interrupt you.
No, not at all. Go ahead, sir.
The email is not from me and not from Highwoods. That email that you're looking at is from Counsel for American Integrity. And it does say our clients accept the offer you conveyed yesterday. But then it goes into detail on what the alleged key terms are that are going to be outlined in this settlement agreement. The first is about the sign. The whole case was about the sign. So clearly that's an essential term. And there's no finality, or there's no agreement on what the sign is going to look like. As you can see, the first paragraph says, it discusses the sign, how it's going to be stacked. And then it says, this provision is subject to Highwoods, my clients, final approval once drawings are submitted. So American Integrity, by this email, is supposed to submit drawings to us for our approval. That approval never happened. So this is a term that's not capable of acceptance because the details on the sign, the thing the whole case was about, have not been worked out yet.
But isn't it more with the, I guess I see it differently, Mr. McLaren, help me out. There was an agreement that there was an agreement as to what, and I think this is what the court said, the essential terms. Okay, we have an agreement. We're going to iron out the details of the signage, the details of the lease and not having to lease certain point. These are all separate and apart from the essential agreement that were the essential terms that both parties agreed. And I guess I'm just, and I know what you've argued before the court, and I know what you've indicated in terms of there's been no agreement, but I'm having a hard time based on this record coming to the conclusion that there was not an agreement to the essential terms.
Well, okay, I think what we have here, Your Honor, is a textbook example of an agreement to agree, which is not enforceable under Florida law. Under the cases we've cited, an agreement to agree is clearly not enforceable. You can't have an agreement under Florida law to, in the future, renegotiate a lease. You have to have terms. The lease in this question was there was a lot more to it than may appear the eye. This 4,500 square feet that was going to be transferred purportedly from American Integrity back to Highwoods, that was worth $699,000 over 4 years. That should be in writing and signed by the party to be charged, in this case, Highwoods. But that provision also, along with the lease space, American Integrity got 18 parking spaces. They got $149,000 in tenant improvement allowance. So what's going to happen with all those other issues? The parties agreed to negotiate a lease amendment. That's all they agreed to. That is not an enforceable agreement under Florida law, as the cases we've cited. The email itself asks who is going to prepare the initial draft of the settlement of the lease amendment. There's going to be a lease amendment. It's going to be drafted. It's going to go back and forth between my client and American Integrity, the tenant, and all these deals are going to be termed out. I mean, if this were an enforceable settlement agreement, there'd be no way for it to be enforced.
But Mr. McLaren, I guess the problem that I'm having isn't in every mediation, the parties agree to the essential terms, then they finalize the details later. This is typically done in mediation. And in here, the problem that I'm seeing is that respectfully, it appears that after you all accepted, somehow it appears that you're trying to get around and saying that, oh no, because all of these, the details that need to be ironed somehow undermines the acceptance of the essential terms. And I apologize, Mr. I've been peppering you, and I know I see Judge LaRose and Judge Smith if they wish to jump in with a question, but I'm just having a hard time based on this record coming to the conclusion that your client have not accepted the essential terms.
I don't know what to say other than these terms, Your Honor, are not capable of acceptance. You can see proposed key terms that are going to form the basis of a settlement. And in every mediation that I've attended in 31 years of practice, if you're going to have a deal, the mediator is very intent on getting everybody to sign the agreement. Here we don't have a signed agreement. That violates the rule. There is no finality. There's no, I mean, look at the email doesn't even include anything about a dismissal of the lawsuit. So under American Integrity's position, my client has agreed to provide all this consideration to it, but my client doesn't even get a dismissal of the lawsuit. There's no indication as to what happens with ReliaQuest. ReliaQuest, are they in the case or not? Do they sign a release? Are there releases or not? I mean, the email and the terms, these were deal points, Your Honor. And in every mediation I've been involved in, the parties discuss the deal points. And then the rubber meets the road. And the lawyers and the parties sit down and they iron out the details. And everybody signs the agreement. That's what Rule 1.730 requires. And in this case, it didn't happen. And
So
Mr. McLaren, if I may help me with my simple approach to things. Let's take a less complicated case. In mediation, the parties agreed defendant shall pay plaintiff $100 and plaintiff will sign a general release to be executed by Attorney Jones. And the mediator, prints it out, everybody initials it. Has it been a meeting of the mind on the essential terms?
If everybody initials it?
Yeah.
Yes, Your Honor, I think that probably would be okay because the parties have initialed, and I think that's arguably close enough to a signature. I'm not sure.
But putting aside the signature, if I apply that to your argument, there has been an agreement to exchange a release yet to be seen.
Well, okay. A release of all claims, some claims. I think that your point is well taken. There's got to be finality. I assumed from your argument, and I apologize for assuming that the release was of all claims. By your language, that's what I assumed. I was wrong, but you're right. Are these releases with respect to all claims with respect to the subject matter of what the case was about, future claims? There still could be details that need to be ironed out. The point is in this case, there's a lot that this email doesn't show. And if this email were truly a settlement agreement, why did the parties continue to negotiate for 3 months? The American Integrity, the plaintiff, sent us an agreement that was a draft settlement agreement after this that contained things like releases and dismissal language, and then said in the email, when the mediator sent it to us, she said, this settlement agreement is still subject to negotiation of the terms of the lease amendment, which we talked about, and also Highwood's final sign approval. None of those things ever happened. So if this alleged agreement were trying to be enforced, I don't know where the court would even start to enforce it. What would the sign look like? What would the lease amendment say?
With that, there's nothing in the record, is there, to suggest why the mediator advised the court that there was a settlement in light of what you've just told us, that there were subsequent discussions?
You are correct, Your Honor. There's nothing in the email.
Okay.
We had asked her in emails leading up, there's no agreement here. Please impasse the mediation and notify the court. And there's nothing in the record to explain that as to why she did that.
And actually, Mr. McLaren, my understanding, client was the one that was proposing new terms.
There were no new terms proposed. What we were trying to do is whittle down the details of what this deal point email was about. I mean, there's nothing in the email about dismissals or releases. That was one of the issues. We continued to negotiate about the sign. American Integrity did send us their proposed sign, and we never got to the point of responding because this dispute arose. The terms of the lease amendment, which is unquestionably an essential term here, the lease amendment, the initial draft never even occurred before this breakdown occurred in terms of negotiation. The rule 1.730, there's not a single case in Florida suggesting that 1.730 does not apply to all mediations. All the cases that we've cited, that this court cited in the recent Parkland case, all say that rule 1.730 that requires a signature of all parties, requires a signature, applies to mediations period. That's what the rule says, and that's what the holdings are. There's no limitation either in the rule or any place where where rule 1.730 does not apply to all mediations. There are some cases where rule 1.730 applies to court-ordered mediations. There are also a lot, including the Kaiser and Scott cases, where
and Mr. McLaren, because I want to make sure time goes quickly during oral arguments, I want you to make sure you both cited as supplemental authority the Parkland case. And Judge Rothstein, you came in the very end, has a sentence, and I want you to address that. And this goes back to my first question to you. We all agree this is a non-court ordered mediation. And here's the language, quote, if the purported settlement agreement had not been reached in the context of a court-ordered mediation, we would likely conclude that it was binding and enforceable. Both parties agreed to have on the essential terms, which is similar to here, and had indicated that their clients were on board. How do you get around that language that, and you've indicated that there's no distinction between court order and non-court order mediation. It appears that our court has basically came out, and let me look at the year. This is fairly recently, and just in November, saying that. How do you distinguish that from here?
Well, in that case, it was simply a court-ordered mediation. But if you look at the actual ruling of the court, it says, the last sentence of the opinion says, in light of Rule 1.730B, we are constrained to conclude that any settlement agreement is unenforceable because it resulted from mediation, yet lacked the party's signature. It doesn't say court-ordered mediation. It says any settlement agreement arising from mediation must be signed by the parties. That's what the ruling is. And this court cites Dean, Gardner, and Mastec, all of those cases with approval. And
So why is that sentence? I mean, the main reason it doesn't say that, because earlier in the paragraph, it says that if this was not in the court order mediation, it would have come totally differently. And so this is the sentence that I'm referring to, Ms. McClellan, the very first sentence of that paragraph. And so why is that sentence there if it doesn't mean what it says?
Well, I mean, it says what it says. In that case, it was a court-ordered mediation. So the court was saying, here we have a court-ordered mediation, so it's binding. It doesn't say if it were not court-ordered, it wouldn't be the same ruling. It just says that in that case, it was a court-ordered mediation. That's the ruling. All the cases cited are non-court-ordered mediations. And in this case, the rule definitely applies because all three parties, not just one, but all three parties filed certifications with the trial court agreeing that this mediation would be conducted pursuant to the rules of civil procedure, including 1.730. The mediator actually filed her notice of mediation notice with the courts, specifically stating that Rule 1.730 applied and that the mediation complied with that rule. And so all parties are stopped from and waived any suggestion that the rule did not apply in this case. So even if Parkland, it only applies to court-ordered mediation, the parties can still agree that the rules apply, which they all did here. So
just clarification, Mr. McLaren, because your certificate doesn't mention.
Excuse me, Judge Kuzan, can I just alert Mr. McLaren that we've chewed away into his rebuttal time, but Mr. McLaren, if you want to listen to and then respond to Judge Kuzam's question. Actually,
if I've peppered him enough, and I think I'll give him the opportunity, Judge LaRose, so I will withdraw my last question.
Okay.
Use your time as you wish, Mr. McLaren. I just wanted to give you a heads up.
Thank you very much. Thanks for the time.
Okay. Mr. Caldevilla.
Good morning, Your Honors. May it please the court. I'm Dave Caldevilla. In my office with me is Brad Barrios, my co-counsel, and we represent American Integrity in this appeal. Your Honor, it's undisputed that Highwoods Counsel conveyed a very specific 5-point settlement offer to us. That offer is in the record at page 775 and in the appendix at page 7. That offer was conveyed by them through the mediator. That's how mediations happen. In mediations, an offer is handed to the mediator or orally expressed to the mediator. The mediator walks into the other room and conveys that offer. In this case, it's actually in writing because after the mediation meeting, the parties continue. Now, that settlement offer does not say that it was contingent upon ReliaQuest accepting the offer. It did not say that the offer was contingent upon the parties and their attorneys signing a formal settlement agreement. It did not say that there had to be a release, et cetera. It's undisputed that American Integrity accepted Highwoods' 5-point offer. Undisputed. The mediation was not court ordered. For reasons that are thoroughly explained in our answer brief, we contend that Rule 1.730 does not apply to non-court ordered mediations. Because that rule does not apply to our mediation, we contend the offer and acceptance resulted in a legally binding settlement agreement under the well-settled principles of contract formation.
And Mr. Caldevilla, if I may,
Yes, ma'am.
because I went back to the original, like Rule 1.700. 1.700, that sets the whole thing, indicates that it either could be, and the language is court ordered, you know, or the court may order mediation, or the parties may enter a written stipulation to mediation. And in this case, there was no written stipulation to mediation among the parties. It just simply, I see there's a notice of mediation. And so in my mind, I'm thinking, okay, the fact that 1.700 has not been triggered because we don't have a court order, we don't have a written stipulation, how can you come through the back door that somehow that the parties have agreed to be bound by 1.730, and that's not listed in the certificate of attendance and authority. That certificate of attendance and authority simply makes reference to the rule of civil procedure that says, here are the folks that have the authority to settle. So I'm having a hard time with, and maybe I should have asked Mr. McLaren, but I peppered him too much. How does this get around? This could be simply parties could all get together, try to resolve the case among themselves. But in this case, they choose to have a third party coming in, and the third party happened to be a mediation. And so help me out. Am I reading this wrong? Am I I'm seeing this differently? Help me out, Mr. Caldevilla.
Well, Your Honor, I agree with what you're saying. In fact, Rule 1.700 is the rule that's common to all mediation and arbitration, and it begins with the premise that there will be an order referring the parties to mediation. That is the basis of the Parkland decision, which I'll get to. But let me suggest to you, Judge, that if this case had resulted in a signed agreement and Highwoods had breached that agreement and we had sought sanctions under Rule 1.730, do you think that Mr. McLaren would be saying that, oh, this was court-ordered mediation? Or do you think he would be saying that that rule does not apply to us because there's no court-ordered mediation? I'll leave that to Your Honors to ponder. But in this case, what happened is after a few weeks after we accepted the settlement agreement, the 5-point offer that they made to us, now Mr. McLaren also says that this was an offer that was not capable of being accepted. So what he's saying is that they formulated an offer, a settlement offer to us that was not capable of being accepted. And when we accepted it, they didn't say, well, wait a minute, we don't have a deal. There's still more that needs to be done here. He's saying he made an offer that's incapable of being accepted. That's pretty far-fetched. But what is significant in this case, and as you pointed out, Judge Kazams, both parties in this case, both parties have cited the Parkland Condo Association versus Henderson case as supplemental authority. And in that case, as Your Honor noted, it says, if the purported settlement agreement had not been reached in the context of court-ordered mediation, we would likely conclude that it was binding and enforceable. So in that case, the court's basically explaining that the signature requirements of Rule 1.730 apply only to a court-ordered mediation, and that Rule 1.730 does not apply in settlement agreements that are not reached in the context of a court-ordered mediation. So for this panel to reverse the trial court's order based on Mr. McLaren's argument that Rule 1.730 applies, I think this court would have to go en banc to recede from Parkland and to expressly hold that 1.730 applies to all mediations, regardless of whether they're court-ordered or not. And let me just say that this is not the only case out of this court that relies on the fact that it's a court-ordered mediation to enforce these rules of civil procedure that govern mediation. The Lazy Flamingo case, RO
Mr. Caldevilla, but the Parkland opinion also, as pointed out by Mr. McLaren, also says that in light of Rule 1.730B, we are constrained to conclude that any settlement agreement is unenforceable because it resulted from a mediation, yet lacked the party's signature. So, let me ask you another question, because and that was briefed by you all. If chapter 44 deals with any mediations like in 44.401 and then court-ordered mediations in 44.102, is it your position that the Florida Supreme Court cannot promulgate a rule that addresses both court-ordered and non-court ordered in the same rules?
Okay, well, I think that the law is clear that the Florida Supreme Court cannot promulgate rules of substantive law. And the formation of a contract is a substantive law, whether
By the signature, you're saying by the actual signature.
Yes, ma'am.
And does it make any difference that I think, the majority of the cases that you're relying are settlement agreements? I don't believe they're both in the context of settlement through mediation. Isn't there a difference with when the settlement agreement arises out of mediation? Are you saying that by the Florida Supreme Court requiring a signature and non-court ordered, that's substantive, but not substantive and court ordered?
Okay, so first of all, I think that the Supreme Court's rules are clear that they only apply to court-ordered mediations because of Rule 1.700. So if
Okay,
we go
so
to the next step, that you can, if we're going to argue, assuming arguendo, that it would apply to any mediation. So that would your honor be saying that the rules apply to non-court ordered mediations that are required as a condition preceded to bring in a lawsuit, or which court ordered mediations, or I'm sorry, which non-court ordered mediations would they apply to? Because there are mediations that occur outside the context of litigation. But let's say that they apply to court ordered and non-court ordered mediations in the context of litigation. Then Chapter 44 does not delegate to the Florida Supreme Court the ability to adopt substantive law with respect to non-court ordered mediations. There's nothing about that there, and we have separation of powers in the Florida Constitution, and it's very clear that when the legislature adopts procedural statutes, that they're subject to being invalidated unless the Florida Supreme Court accepts those, like we have with the Florida Evidence Code, for example. And the vice versa is true. If the Florida legislature hasn't given the Florida Supreme Court the authority to promulgate substantive law, then that's subject to attack as being unconstitutional by the separation of powers doctrine. But in this case, it's clear that we don't have a court-ordered mediation. If I can move on, Judge, I don't know. I'm not pivoting. Did I answer your question?
I think you've answered my question. Thank you.
All right, thank you. So counsel says that, well, we've stipulated that this is a court-ordered mediation because of the certification form that was filed in this case. Let's talk about that. He says that at pages 1 and 7 of his reply brief, that we stipulated that mediation would be conducted pursuant to the rules of civil procedure in the certificate of authority. Now, that argument is without merit for a couple of reasons. First, Highwood's argument about the certificate of authority is not mentioned in the initial brief. It's raised for the first time in the reply brief. So procedurally, it's waived. But second, on the merits, the certificate of authority does not stipulate that the mediation is court ordered or that the mediation will be governed by the rules of civil procedure. What it says is that plaintiff American Integrity, and pursuant to Rule 1.720, files the certificate of authority in advance of the mediation, we identify who's going to be attending the mediation as a party representative, and that they have the authority as required by this rule. Now, we're not stipulating that the rule governs. The purpose of the certification is merely to identify who would be attending the mediation and confirm that they have authority to settle. That citation to the rule is superfluous, and it can't be extrapolated into a stipulation. I mean, what if American Integrity's certificate of authority had said that that the certification was being provided pursuant to the Constitution of the state of Alabama? Would that mean that we've stipulated and that we're judicially stopped from contending that the mediation is not governed by the Constitution of the state of Alabama? I don't think so. I think it's superfluous. I think it has no bearing. Counsel has not talked about his statute of frauds argument, but well, let me talk about a couple of other things that he has brought up before I get to that.
And Mr. Caldevier, let me ask you a question, because what concerns me with this is that you worry about unintended consequences. If we do what Mr. McLaren is asking us to do, that if based on this record, okay, there's an acceptance, that means, and from now on, lawyers will tell their clients, let's go to mediation. Let's just assume court order mediation. Yeah, we'll agree. Oops, let's not sign anything, refuse to sign. Or later on, there's an agreement, let's not sign. And suddenly all these hours of going back and forth, it's almost like a gotcha litigation, gotcha whatever, to try to undermine an agreement by just informing their clients, oh, we could get around this, or having second thoughts or whatever, because not having the client's signature. That troubles me. That troubles me. And so I don't know if that's a valid concern when we're evaluating this case.
Your Honor, certainly it's valid. I've been practicing law for 35 years, and I can tell you that, there have been mediations that I've walked out of where sometimes one of the parties gets buyer's remorse, as we call it, and they're not happy with the settlement that they've reached. And we have to resolve these things. That can be obviously very problematic. And what the public policy in Florida is to encourage settlements and to do everything. The courts are actually instructed by the Florida Supreme Court to do everything they can to uphold a settlement agreement. And of course, we have the Tipsy-Coachman doctrine that requires the courts to do everything in their power to affirm a decision if it's supported, the trial court's decision, if it's supported by the record. So I absolutely agree that this could be a Pandora's box to write a decision reversing here that says, well, the parties get an opportunity to, you can make a 5-point settlement agreement, and then after the other side accepts it, say, oh, but we also want to add in this other party that we didn't mention. We were having side conversations with them, and we really intended to include that as part of your offer, even though we didn't, but we really meant to do that, and so no settlement. Now, if you even read their motion to void the settlement agreement, Judge Kuzan, their motion includes an alternative motion that if you do enforce the settlement agreement, please make ReliaQuest, make them join in the settlement agreement. So where does that come from? They never accepted anything, but yet Highwoods is happy to have the trial court force ReliaQuest to be part of this agreement that there's no evidence at all of them ever being accepted. But the agreement that we accept, they want to unravel. The fact that there was no release or voluntary dismissal mentioned here is just one of the terms that get ironed out in any settlement. It's the cases that we cite in our answer brief at pages 24 and 25, the Nichols versus Hartford case out of the first DCA, Earhart versus Duff out of the fourth DCA, Nichols versus Martell out of the third DCA. Those are all cases that acknowledge that, yeah, typically a release is part of the settlement, and even though it's not mentioned in the actual essential terms of the settlement, that the fact that one of the parties is expecting a release is not going to invalidate or create a counteroffer or change the fact that a settlement's been reached. And even if we refuse to sign a release or file a notice of voluntary dismissal, does anyone think that they wouldn't be able to file a motion to dismiss because the case moot, because we now have a settlement agreement that everybody's agreed to? Of course not. There would be a motion to dismiss for mootness, or there'd be a motion to enforce that there's been a settlement. That means that there has to be a voluntary dismissal or a release, or both. So, counsel also mentions that, oh, if there was an agreement, why was there 3 months of negotiations thereafter? Well, there's 3 months of negotiations after because they wanted to make ReliaQuest join in this settlement agreement that they weren't a party to. That was the holdup. The fact that the sign, whether the sign was going to be approved or not, that is a term of the settlement agreement, that the sign had to be approved by ReliaQuest. It was not a condition that had to be satisfied in order to reach a settlement agreement, or had to be done before there was a settlement agreement. This is just like in any lease, Your Honor. If there's signage involved, or there's alterations to be made to the lease premises, there's always a provision that says that it's going to be subject to the landlord's approval. That's what this settlement term is here. So that is not an agreement to agree, and neither is the fact that the parties contemplated that there would be an amendment to the lease. The amendment itself is very clearly set out in Highwoods' offer. Their offer says what the amendment would be, and now they haven't raised it yet today, but in their brief they raised the statute of frauds. Well, the statute of frauds doesn't apply here. The very first part of the statute of frauds says no action shall be brought under these situations. Well, we're not bringing an action to enforce any lease. We're seeking to enforce our settlement agreement. If there's a problem with them, once the settlement agreement is enforced, if they refuse to produce the lease that matches up with the terms of this settlement agreement, we can take that up later by a separate motion or separate breach of contract. But that is not a violation of the statute of frauds. It's a premature argument because we haven't brought an action. But not only that, the statute of frauds does not apply when the party seeking to enforce it has already partially or fully performed. We fully performed. We provided our drawings to them and asked them to approve them. They haven't approved them, but we've done everything. We've done everything that we were asked to do under their 5-point settlement agreement. And not only that, the statute of frauds also does not apply to equitable remedies. And so if we were to seek an equitable remedy as a result of this, then the statute of frauds simply does not apply. So unless Your Honors have any other questions for me, I think everything's been addressed in our answer brief, and we would stand on our answer brief with respect to the rest of this and request this court to affirm. Thank you.
Perfect timing, right at 20 minutes.
I didn't plan it that way.
Mr. McLaren, rebuttal, please.
Yes, Your Honor. Let's first of all, I'd like to talk about the fact that the parties did agree that this mediation would be governed by the rules of civil procedure. It wasn't just one party that filed a notice of mediation. All three parties filed a certificate pursuant to Florida Rule of Civil Procedure 1.720, identifying their attendees and saying that those individuals would follow Rule 1.720. If the mediation wasn't governed by the rules of civil procedure, why would Rule 1.720 apply? And this issue was raised on page 4 of our initial brief. It's right. I could read it to the court, but it's right there. It's in writing on page 4 and elsewhere in the brief. Regarding the issue of how this is not an offer capable of acceptance, counsel suggests that that's somehow some untoward idea. The idea in mediation is open and honest communications. That's the whole idea of requiring signatures. So there are not gotcha litigation tactics when someone says, hey, what about this deal? Would this potentially work? And no one says, oh, gotcha, agreement. That's why people have to sit down and actually draw out an agreement and sign it. Regarding why it took so long, it took 10 days after August the 10th for American Integrity to prepare the initial draft, as they point out, of the actual settlement agreement that had the necessary details. And it came back to us and we redlined it and it sent it back to them. When American Integrity sent that proposed settlement agreement to us, it was with caveats. This is not final. Can't be final until our sign's approved and until the lease negotiations about the lease amendment have been finalized. So that's why it took so long. Regarding chapter 44.
But in all fairness, Mr. McLaren, it took a long time because didn't your client started injecting new things? And I mean, I've been seeing, and for you to say gotcha litigation and whatever, I'm having a hard time because if you look at this record where your client proposed essential terms, the other side agrees, then with the understanding that the folks are going to prepare, you know, the appropriate release, appropriate documentation, and then suddenly new things are being injected, new things are being done, which adds more delay and more delay. This is the part that troubles me because once you have an agreement, there should not be any gamesmanship. And that's what really troubles me, Mr. McLaren.
Well, Your Honor, I can assure you that there was absolutely no gamesmanship on our part. We were told by the mediator that ReliaQuest was willing to sign a release. During the July 27th mediation, all 4 Highwoods attendees heard it and we informed the trial court of that. So it's in the record. So all along, our understanding is that when we get down to the nitty gritty and we start drafting the actual settlement agreement and talk about dismissals, that ReliaQuest was going to be a party. When American Integrity sent us their form, it was like 7 or 8 pages long. So it had all kinds of details that weren't in the original email. We responded to that with additional changes. And so, Your Honor, very respectfully, we didn't insert new provisions that were not contemplated by Highwoods at the time of August the 10th. All of those were always contemplated. And as soon as we got the formal email without ReliaQuest and without some of the other details that we intended to include, such as a dismissal and releases, we responded and we pointed out. And so that was in late August. And then the last 2 months were spent trying to finalize the agreement, et cetera, et cetera. And so I can assure Your Honor that on my behalf and on clients in good faith as an officer of their court, there was absolutely no gamesmanship on anyone's part in this situation. Highwoods did not change their mind. They wanted a deal, but they wanted a deal to end this case. If Highwoods supplied all this consideration to American Integrity and there was still a case going on and ReliaQuest didn't dismiss it, why would Highwoods want to settle this case on one day and then end up a defendant by ReliaQuest on a related issue the next day? That's why it was important to get all this nailed down. Regarding
Mr.
chapter
McLaren,
44.
you're up to your 5 minutes, so if you could wrap it up, we'd appreciate it.
Yes, Your Honor. Thank you for the time this morning. Very much appreciated. You know, I could go on, but obviously I'm out of time. So thank you very much for the time this morning. I appreciate it.
Thank you.
Thank you,
Thank
Mr.
you both.
McLaren.
Your Honors.
Thank you, Mr.
Thank you.
Calavia. Very interesting case.
It really is.
With that, we are adjourned.
Thank you.
Thank you.